Welcome to episode 47 on the Law Rapport. Today I'm going to discuss the amendments to the Crown Land Ordinance and the Amnesty Bill. These amendments and the Amnesty Bill itself were recently explained in the House of Assembly by the Attorney General of the Turks and Caicos Islands, and the Sun newspaper, its online edition, published the full explanation given by the Attorney General. This is an important development in the Turks and Caicos Islands, given the issues of Crown Land has been for many years debated hotly in the public arena. Before I get into the discussion, my usual disclaimer: this is not legal advice, should not be construed as legal advice. For legal advice, please contact an attorney of your choice. Welcome back. According to the report in the TCI Sun, the Attorney General provided a detailed explanation on the amendments to the Crown Land Ordinance and the Amnesty Bill that was recently passed in the House of Assembly. The report states that the Attorney General indicated that the first phase primarily focuses on residential conditional purchase leases, as the majority of inquiries from customers of the Crown Land unit relate to conditional purchase leases. The Attorney General said that the Crown Land Ordinance in its current form presented challenges for security of tenure for residential development. She said the requirement for lessees to convert their residential conditional purchase leases, or CPL, to freehold title provided limited options and had proven somewhat burdensome due to the increasing values in land in the Turks and Caicos Islands, and thus had essentially marginalized that segment of the community in spite of the 25% discount that was offered on the purchase price. She noted that through the amendment order, which took effect on the 13th of February 2023, the available discount to Turks and Caicos Islanders for purchasing residential Crown Land was increased to 50%. She also noted that the new measures under the Crown Land Amendment Bill 2023 will permit the exchange of land. She said there were current examples of cases involving governments mistaking occupation of portions of private land, or private landowners mistaking occupation of portions of Crown Land. The practical solution, she said, to rectifying these encroachment issues would be to facilitate an exchange of government land for use of private parcel or vice versa. Unfortunately, the Crown Land Ordinance does not provide for such an exchange, particularly where government land to be exchanged is zoned for residential development. An allocation of Crown land is dictated by the criteria stipulated in the Crown Land Ordinance and cannot be disregarded unless an amendment is made to facilitate an exchange as recommended, the Attorney General explained. Therefore, according to the Attorney General, the bill seeks to amend Section 9 of the Crown Land Ordinance to include a provision to permit the exchange of land in cases where the government has used private land or where a private landowner has used Crown land under a mistaken belief that it is entitled to that land and has relied on the mistaken belief to its detriment, on the condition that 1. The land transferred is equivalent value to that land as certified by the Chief Valuation Officer, or a payment is made to achieve such equivalence, and the exchange is exempt from stamp duty and should not trigger the repayment of the islander discount. The Attorney General went on to say that there will be an extended time period for the acceptance of an offer. She said that the 3 months time period within which an applicant is offered to purchase freehold has proven to be too short to allow for the processing of mortgages and other financing. She added that the loan approval process is usually not completed within the 3 months period, resulting in the applicant's offer lapsing. In order for the applicant to once again avail himself of the opportunity, a new application has to be made. The existing Crown Land Ordinance makes no provision for the period to be extended beyond the 3 months. The bill, she said, seeks to amend Section 33, subsection 8 of Schedule 2 of the Crown Land Ordinance to extend the period during which a successful applicant may accept an offer letter for the purchase of the freehold title for Crown land from 3 months to 6 months. The Attorney General went on to address the issue of the Crown Land Advisory Panel and the procedure for the assignment of leases. She noted that the requirement for the application to be considered by the Crown Land Advisory Panel is subject to the availability of a quorum, which may result in delays and hardship to the leasee who is to sublet the property or assign the lease. She said the requirement for consent is procedural, as the application or as the applicant would be holding the current lease and would have satisfied the requirement for his allocation. Any issues concerning the new assignee subleasee could be addressed by seeking input from the relevant specialists or technical experts, particularly representatives from the Crown Land Unit and the Department of Environment. The exportees would not be restricted to those two representatives, but would also not require input from the full advisory panel. She explained. She said that the bill seeks to amend Section 35(1) of the Crown Land Ordinance to remove the advisory panel's consultative function in respect of a leaseholder's application to assign or sublet a lease, and replace it with a duty on the governor to consult representatives from the Crown Lands Unit and the Department of the Environment and other such persons as he deems necessary. It also appears that the bill introduced a new transitional option for residential conditional purchase lease. The Attorney General stated that from a government perspective, it is extremely useful to have a formal surrender in place if the person is not going to exercise any of the transitional options available to them under Section 36 of the Crown Land Ordinance. The reason for this, according to the Attorney General, is that the Turks and Caicos Islands government does not always have a record of the position on the ground. Therefore, if surrenders are filed for those parcels which have been abandoned, then government records can easily be updated and make the land available for other development. However, if surrenders have not been filed, the Turks and Caicos Islands government must investigate the position on the ground, try to locate the claimants who might have held under a CPL or conditional purchase lease that land, serve notice to warn them of the intention to repossess, which can be a very lengthy process, she explained. It is therefore of significant benefit to the public land management if the title to the plot can quickly be resolved by a formal surrender. However, the requirement under the Crown Land Ordinance to pay all outstanding rents and means profit complicates this process and adds an additional financial burden on the CPL or the Crown Land purchase lease holder who wishes to relinquish all claims to the land. As a result, many CPL holders have failed to surrender the land, as surrendering is not different to holding on to the expired CPL, as in both cases the rent and means profit is payable. She said the bill seeks to amend Section 36, subsection 6 of Schedule 2, Part C of the Crown Land Ordinance to remove the requirement for the payment of arrears and means profit when a CPL is surrendered. The bill also introduces a provision to permit, where the holder of an expired residential CPL has passed away, the executor or administrator of the estate to apply to regularize the land, provided that the property was being used as the primary residence of the deceased. The Attorney General explained that under the existing ordinance, the right to purchase the freehold does not pass to the heirs and the death of the holder of an expired conditional purchase lease. Therefore, any investment and the land is lost, as no member of the family could inherit the right. Notwithstanding this, there are cases where the Crown Land Unit has permitted transfer of the title to the administrator of the estate following the passing of the holder of an expired CPL. It is for these reasons that a provision is now being incorporated into the Crown Land Ordinance to permit the transferability of the right for the future and giving legal recognition to any transfers that has been made in the past, she explained. Now, the Attorney General dealt with enforcement and compliance notices. The Attorney General said that the Crown Land Unit has been unable to effectively serve enforcement notices as the department has found it difficult to contact the leasee due to lack of contact information, and the methods of service stipulated in the Crown Land Ordinance is restricted to delivery to the last known address by hand, by mail, and by electronic service. It is therefore necessary to introduce other method of services. She said the bill therefore amends Section 49 of the Crown Land Ordinance to include displaying the notice in a prominent place on the land affected and publishing it in 3 consecutive issues of the Gazette as additional methods of service of notices relating to the non-compliance with the terms or conditions of any grant, wherever service cannot be effected in one of the ways previously mentioned. Now, here is where I will leave it for today. In part 2, I will discuss the explanation given by the Attorney General to the Crown Land Residential Conditional Purchase Lease Arrears and Means Profit Amnesty Bill 2023. I thank you for watching, and I hope to see you in another episode.